Law PH now. Full Q and A-style reviewer and flashcard set for civil procedure based on the 2025 Philippine Bar Exam syllabus. It will cover 1. General principles. 2. Jurisdiction. 3. Actions, causes of action, and parties. 4. Pleadings and motions. 5. Pretrial and trial. 6. Judgments and final orders. 7. Appeals. 8. Provisional remedies. 9. Rule on summary procedure. 10. Rule on small claims. I'll send the full set in manageable sections across the next few messages. Let's start with Part 1, General Principles and Jurisdiction. Civil Procedure, Part 1, General Principles and Jurisdiction. Q1, what is remedial law? A. Remedial law prescribes the methods of enforcing rights or obtaining redress for their violation. Legal basis, rules of court, Rule 1, Sector 1. Q2, what is the nature of procedural law? A. It is substantive in form but procedural in nature. It governs the mode and method by which rights are enforced. Case, Fabian v. Desierto, GR number 129742, 1998. Q3, who has the authority to promulgate rules concerning pleading, practice, and procedure in all courts? A. The Supreme Court. Legal basis, Article 8, Sector 5, 1987 Constitution. Q4, what are the limitations on the Supreme Court's rulemaking power? A. The rules must be uniform for all courts of the same grade. Not diminish, increase, or modify substantive rights. Take effect only after publication. Legal basis, 1987 Constitution, People v. Vera, GR No. L45685. Q5, what is jurisdiction? A. Jurisdiction is the power and authority of a court to hear, try, and decide a case. Legal basis, Rule 2, Sector 1, Rules of Court. Q6, what are the kinds of jurisdiction? A. 1. Jurisdiction over the subject matter. 2. Jurisdiction over the person. 3. Jurisdiction over the residential or property. 4. Jurisdiction over the issues. Case, Banco Español Filipino v. Palanca, GR No. L11390. Q7, how is jurisdiction over the subject matter conferred? A. By law. It cannot be acquired by consent, waiver, or estoppel. Case, La Naval Drug Corporation v. ECA, GR number 103200. Q8, what determines jurisdiction over the subject matter in civil cases? A. Primarily the allegations in the complaint, including the nature of the action and the amount of the claim. Case, VDA. De Manguera v. Rizos, GR number 139287. Q9, how is jurisdiction over the person of the plaintiff acquired? A. Upon filing of the complaint. Legal basis, Rules of Court. Q10, how is jurisdiction over the person of the defendant acquired? A. By service of summons or voluntary appearance. Case, De Midgley v. Ferrandos, GR No. L32615. Would you like me to continue with Part 2, Actions, Causes of Action, and Parties, now? Great. Here's the next section. Civil Procedure, Part 2, Actions, Causes of Action, and Parties. Q11, what is an action? A. An action is a judicial demand for the enforcement or protection of a right, or for the prevention or redress of a wrong. Legal basis, Rule 1, Sector 3, A, Rules of Court. Q12, what are the kinds of actions? A. 1. Civil actions, for enforcement or protection of a right or redress of a wrong. 2. Criminal actions, for punishment of crimes. 3. Special proceedings, for establishment of a status, right, or fact. Legal basis, Rule 1, Sector 3, Rules of Court. Q13. What is a cause of action? A. The act or omission by which a party violates a right of another. Legal basis. Rule 2, Sector 2, Rules of Court. Q14. What are the requisites of a cause of action? A. 1. A legal right in favor of the plaintiff. 2. A corresponding obligation on the part of the defendant. 3. An act or omission of the defendant in violation of the right. Case, Mayo Sugar Central Company v. Barrios, Gr. No. L13209. Q15. What is a real party in interest? A. The party who stands to be benefited or injured by the judgment, or is entitled to the avails of the suit. Legal basis. Rule 3, Sector 2, Rules of Court. Q16. What is the rule on capacity to sue or be sued? A. Every person who has the legal capacity to sue or be sued may be a party. Juridical entities may sue or be sued in their corporate name. Legal basis. Rule 3, Sector 1, Rules of Court. Q17. What is joinder of parties? A. It is the inclusion of multiple parties, plaintiffs or defendants, in one complaint or action when a common question of law or fact is involved. Legal basis. Rule 3, Sector 6, Rules of Court. Q18. What is misjoinder or non-joinder of parties? A. It is not a ground for dismissal. The court may order the inclusion or exclusion of parties. Legal basis. Rule 3, Sector 11, Rules of Court. Q19. What are indispensable parties? A. Those without whom no final determination can be had. Their presence is essential to the case. Legal basis. Rule 3, Sector 7, Rules of Court. Q20. What are necessary parties? A. Those who are not indispensable but ought to be joined to afford complete relief. Legal basis. Rule 3, Sector 8, Rules of Court. Next up is Part 3, Pleadings and Motions. Ready for that section? Here is Part 3, Pleadings and Motions under Civil Procedure for the 2025 Philippine Bar. Civil Procedure, Part 3, Pleadings and Motions. Q21. What is a pleading? A. A pleading is a written statement of the respective claims and defenses of the parties. Legal basis. Rule 6, Sector 1, Rules of Court. Q22. What are the kinds of pleadings allowed under the Rules of Court? A. 1. Complaint. 2. Answer. 3. Counterclaim. 4. Cross-claim. 5. Third-party complaint. 6. Reply, only if the answer contains an actionable document. Legal basis. Rules 6 to 11, Rules of Court. Q23. What is a complaint? A. A complaint is a pleading alleging the plaintiff's cause or causes of action. Legal basis. Rule 6, Sector 3, Rules of Court. Q24. What is an answer? A. An answer is a pleading in which a defending party sets forth their defenses. Legal basis. Rule 6, Sector 4, Rules of Court. Q25. What are affirmative defenses? A. Allegations in an answer which, if true, would defeat the plaintiff's claim even if the allegations in the complaint are true. Examples: prescription, lack of jurisdiction, residential judicata. Legal basis. Rule 8, Sector 5, Rules of Court. Q26. When should a motion to dismiss be filed under the revised rules? A. Most grounds for dismissal must now be raised as affirmative defenses, except for lack of jurisdiction over the subject matter which may be raised at any time. Legal basis. Rule 15, Rule 6, AM number 19-10-20 SC. Q27. What is a motion? A. A motion is an application for relief other than by a pleading. Legal basis. Rule 15, Sector 1, Rules of Court. Q28. What are litigious and non-litigious motions? A. Non-litigious motions do not require hearing, e.g., motion for extension of time. Litigious motions require the other party's comment and court resolution, e.g., motion to dismiss. Legal basis. Rule 15, Sex. 4 to 6, Rules of Court. Q29. What is the rule on notice and hearing of motions under the revised rules? A. Litigious motions must be served with a notice and given 5 calendar days for opposition. The court resolves them within 15 calendar days from receipt of opposition or lapse of the period to file opposition. Legal basis, Rule 15, Sex. 4 to 6, as amended. Q30. What is a bill of particulars? A. A bill of particulars is a pleading filed to clarify vague allegations in the complaint. Legal basis, Rule 12, Sex. 1 to 2, Rules of Court. Let me know when you're ready to continue with Part 4, Pre-Trial and Trial. Here is Part 4, Pre-Trial and Trial under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 4, Pre-Trial and Trial. Q31. What is the purpose of pre-trial? A. To simplify the issues, consider the possibility of an amicable settlement, mark evidence, and facilitate a speedy disposition of the case. Legal basis, Rule 18, Sector 1, Rules of Court. Q32. Is pre-trial mandatory? A. Yes. Non-appearance by a party may result in dismissal or being declared in default. Legal basis, Rule 18, Sex. 2 and 5, Rules of Court. Q33. What is the effect of failure to appear at pretrial? A. If the plaintiff fails to appear, case may be dismissed with prejudice. If the defendant fails to appear, may be declared in default. Legal basis, Rule 18, Sector 5, Rules of Court. Q34. What must the parties submit before pretrial? A. A pretrial brief at least 3 calendar days before pretrial. Legal basis, Rule 18, Sector 6, Rules of Court. Q35. What happens if a party fails to file a pretrial brief? A. It is equivalent to non-appearance at pretrial. Legal basis, Rule 18, Sector 6, Rules of Court. Q36. What is judicial affidavit rule compliance in pretrial? A. The parties must submit the judicial affidavits of their witnesses in lieu of direct testimony. Legal basis, AM number 12-8-8 SC, Judicial Affidavit Rule. Q37. What is the one-day examination of witness rule? A. The direct, cross, and redirect examination of each witness must be completed within 1 day. Legal basis, AM number 03-1-09 SC, Rule on Continuous Trial. Q38. When does trial proper begin? A. After the pre-trial order is issued and the case is set for trial dates. Legal basis, Rule 18, Sex. 7 to 8, Rules of Court. Q39. What is the order of trial in civil cases? A. 1. Plaintiff presents evidence. 2. Defendant presents evidence. 3. Plaintiff may present rebuttal. 4. Defendant may present surrebuttal. Legal basis, Rule 30, Sector 5, Rules of Court. Q40. What is the effect of a party's failure to appear during trial? A. If the plaintiff fails to prosecute without justifiable cause, case may be dismissed. If the defendant fails to appear, trial may proceed ex parte. Legal basis, Rule 17, Sector 3 and Rule 18, Sector 5, B, Rules of Court. Ready to continue with Part 5, Judgments and Final Orders? Here is Part 5, Judgments and Final Orders under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 5, Judgments and Final Orders. Q41. What is a judgment? A. A judgment is the final adjudication by the court of the rights of the parties in a case. Legal basis, Rule 36, Sector 1, Rules of Court. Q42. What is the difference between a final judgment and an interlocutory order? A. Final judgment disposes of the case completely and finally. Interlocutory order resolves an issue without terminating the case. Case, BPI v. Far East Molasses, GR No. L24745. Q43. What is a judgment on the pleadings? A. Rendered when an answer fails to tender an issue or admits the material allegations of the complaint. Legal basis. Rule 34, Sector 1, Rules of Court. Q44. What is a summary judgment? A. Granted when there is no genuine issue of fact and the moving party is entitled to judgment as a matter of law. Legal basis. Rule 35, Sector 1, Rules of Court. Q45. What is required for a valid judgment? A. It must be 1. In writing. 2. Personally and directly prepared and signed by the judge. 3. Contain clearly the facts and the law upon which it is based. Legal basis. Rule 36, Sector 1, Rules of Court. Q46. What is the rule on judgment by default? A. If the defending party fails to answer within the time allowed, the court may render judgment granting the relief prayed for. Legal basis. Rule 9, Sector 3, Rules of Court. Q47. What remedies are available from a judgment? A. 1. Motion for reconsideration or new trial, Rule 37. 2. Appeal, Rules 40 to 43, 45. 3. Petition for relief from judgment, Rule 38. 4. Annulment of judgment, Rule 47. Q48. What is a motion for new trial? A. A request to retry the case on grounds such as fraud, accident, mistake, or newly discovered evidence. Legal basis. Rule 37, Sector 1, A, Rules of Court. Q49. What is a motion for reconsideration? A. A request for the court to review and reverse or modify a judgment based on errors of law or fact. Legal basis. Rule 37, Sector 1, B, Rules of Court. Q50. Within what period must a motion for new trial or reconsideration be filed? A. Within 15 calendar days from notice of judgment or final order. Legal basis. Rule 37, Sector 1, Rules of Court. Next is Part 6, Appeals. Would you like me to proceed? Here is Part 6, Appeals under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 6, Appeals. Q51. What are the modes of appeal in Philippine civil procedure? A. 1. Ordinary appeal, Rule 40, from MTC to RTC. 2. Appeal by record on appeal, Rule 41, from RTC to CA in special cases. 3. Petition for review, Rule 42, from RTC to CA in appealed decisions from MTC. 4. Appeal by certiorari, Rule 45, from CA, RTC, CTA to the Supreme Court on pure questions of law. 5. Petition for review on certiorari, Rule 45, from CTA and Bank to Supreme Court. 6. Petition for review under Rule 43, from quasi-judicial bodies to CA. Q52. What is the period to file an ordinary appeal, Rule 40? A. Within 15 calendar days from notice of judgment or final order. Legal basis. Rule 40, Sector 2, Rules of Court. Q53. What is the period to appeal from RTC to CA under Rule 41? A. Within 15 calendar days from notice of judgment or final order. Legal basis. Rule 41, Sector 3, Rules of Court. Q54. When is record on appeal required? A. Only in special proceedings or in cases of multiple appeals. Legal basis. Rule 41, Sector 3, Rules of Court. Q55. What is a petition for review under Rule 42? A. A mode of appeal from the RTC, in its appellate jurisdiction, to the CA, raising questions of fact, law, or both. Legal basis. Rule 42, Sector 1, Rules of Court. Q56. What is the period to file a petition for review under Rule 42? A. Within 15 days from notice of decision, extendable by 15 more days for just cause. Legal basis. Rule 42, Sector 1, Rules of Court. Q57. What is an appeal by certiorari under Rule 45? A. A mode of appeal from the CA, CTA, or RTC to the Supreme Court on pure questions of law. Legal basis. Rule 45, Sector 1, Rules of Court. Q58. What is the period to file a Rule 45 appeal? A. Within 15 days from notice of judgment, extendable by another 30 days for justifiable reason. Legal basis, Rule 45, Sector 2, Rules of Court. Q59. Can errors of fact be reviewed in a Rule 45 appeal? A. No, only questions of law are allowed in Rule 45. Legal basis, Rule 45, Sector 1, Rules of Court. Q60. What is the effect of perfection of appeal? A. It divests the trial court of jurisdiction over the case, except for certain residual powers. Legal basis, Rule 41, Sector 9, Rules of Court. Shall we continue with Part 7, Provisional Remedies? Here is Part 7, Provisional Remedies under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 7, Provisional Remedies. Q61. What are the provisional remedies under the Rules of Court? A. 1. Preliminary attachment, Rule 57. 2. Preliminary injunction, Rule 58. 3. Receivership, Rule 59. 4. Replevin, Rule 60. 5. Support pendant light, Rule 61. Q62. What is the purpose of provisional remedies? A. To preserve and protect the rights or interests of a party during the pendency of an action. Legal basis, Rules 57 to 61, Rules of Court. Q63. What are the grounds for preliminary attachment? A. Among others. To recover a specified amount of money, not secured. Fraudulent disposal of property. Defendant is a non-resident. Defendant is about to abscond. Legal basis, Rule 57, Sector 1, Rules of Court. Q64. What must be shown to obtain a writ of preliminary attachment? A. Applicant must show by affidavit and bond that 1. A sufficient cause of action exists. 2. The case falls under Rule 57, Sector 1. 3. No other sufficient security is available. 4. Amount due is stated. Legal basis, Rule 57, Secs. 3 to 4, Rules of Court. Q65. What is preliminary injunction? A. A remedy requiring a party to refrain from or perform a particular act to prevent grave and irreparable injury. Legal basis, Rule 58, Sector 1, Rules of Court. Q66. What is the difference between a temporary restraining order, TRO, and a writ of preliminary injunction? A. TRO, immediate, short-term relief, 20 days from RTC, 60 days from CA. Preliminary injunction, requires notice and hearing, remains until lifted or modified. Legal basis, Rule 58, Secs. 5 and 7, Rules of Court. Q67. What are the requisites for a writ of preliminary injunction? A. 1. Clear legal right. 2. Material and substantial invasion of that right. 3. Urgent necessity to prevent serious damage. Legal basis, Rule 58, Sector 3, Rules of Court. Q68. What is receivership? A. A remedy where the court appoints a receiver to manage property in litigation to preserve it. Legal basis, Rule 59, Sector 1, Rules of Court. Q69. What is replevin? A. An action to recover possession of personal property wrongfully detained. Legal basis, Rule 60, Sector 1, Rules of Court. Q70. What are the requisites for replevin? A. 1. Affidavit showing right to possession. 2. Property is wrongfully detained. 3. Description and actual market value. 4. Applicant files bond. Legal basis, Rule 60, Sector 2, Rules of Court. Like to proceed to Part 8, Special Civil Actions? Here is Part 8, Special Civil Actions under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 8, Special Civil Actions, Rules 62 to 71. Q71. What are special civil actions? A. These are civil actions governed by specific rules due to their distinct nature, although they remain governed by ordinary rules when applicable. Legal basis, Rules 62 to 71, Rules of Court. Q72. What is interpleader? Rule 62. A. An action filed by someone who claims no interest in the subject matter but is exposed to multiple claims, and seeks the court to determine the rightful claimant. Legal basis, Rule 62, Sector 1, Rules of Court. Q73. What is declaratory relief? Rule 63. A. An action to determine the rights of parties under a deed, will, contract, or statute before a breach or violation occurs. Legal basis, Rule 63, Sector 1, Rules of Court. Q74. What is certiorari as a special civil action? A. A remedy to annul an act of a tribunal or officer exercising judicial or quasi-judicial functions done with grave abuse of discretion and where there is no appeal or plain remedy. Legal basis, Rule 65, Sector 1, Rules of Court. Q75. What are the elements of certiorari under Rule 65? A. 1. Act was judicial or quasi-judicial. 2. Tribunal acted without or in excess of jurisdiction or with grave abuse of discretion. 3. No appeal or other plain, speedy, adequate remedy exists. Legal basis, Rule 65, Sector 1, Rules of Court. Q76. How is prohibition different from certiorari? A. Prohibition prevents a tribunal from continuing to act without or in excess of jurisdiction, while certiorari annuls acts already done. Legal basis, Rule 65, Sector 2, Rules of Court. Q77. What is mandamus? A. A writ commanding a tribunal or officer to perform a duty required by law and unlawfully neglected. Legal basis, Rule 65, Sector 3, Rules of Court. Q78. What is quo warranto? Rule 66. A. A remedy to determine the right of a person to a public office or position and oust one unlawfully occupying it. Legal basis, Rule 66, Sector 1, Rules of Court. Q79. What is expropriation? Rule 67. A. The state's power to take private property for public use upon payment of just compensation. Legal basis, Rule 67, Sector 1, Rules of Court, Art. 3, Sector 9, 1987 Constitution. Q80. What is foreclosure of real estate mortgage? Rule 68. A. A remedy to enforce a mortgage lien, allowing the mortgaged property to be sold if the debt is unpaid. Legal basis, Rule 68, Sector 1, Rules of Court. Would you like me to continue with Part 9, Special Proceedings, or would you prefer flashcards summarizing what we've covered so far? Here is Part 9, Special Proceedings under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 9, Special Proceedings, Rules 72 to 108. Q81. What are special proceedings? A. Special proceedings are a type of court procedure designed for matters involving specific situations such as probate, adoption, and judicial settlements of estates. These proceedings are governed by their own specific rules. Legal basis, Rules 72 to 108, Rules of Court. Q82. What is the procedure for probate of a will? Rule 73. A. The procedure involves filing a petition for probate, notifying interested parties, and the court determining whether the will is valid. The estate is then administered according to the terms of the will. Legal basis, Rule 73, Sector 1, Rules of Court. Q83. What is the difference between testate and intestate proceedings? A. Testate proceedings involves the administration of an estate with a valid will. Intestate proceedings involves the administration of an estate when the decedent dies without a will. Legal basis, Rule 73, Sector 1, Rules of Court. Q84. What is a judicial settlement of an estate? Rule 74. A. A judicial settlement involves the court overseeing the settlement of the estate of a decedent, including the determination of heirs, debts, and distribution of assets. Legal basis, Rule 74, Sector 1, Rules of Court. Q85. How are claims against an estate handled in special proceedings? Rule 86. A. Claims must be filed within a specified period after the publication of the notice of hearing, and the court will determine which claims are valid and which will be paid from the estate. Legal basis, Rule 86, Sector 3, Rules of Court. Q86. What is adoption and its procedure? Rule 99. A. Adoption is the legal process of establishing a parent-child relationship between persons who are not biologically related. It requires a petition, investigation, and approval by the court. Legal basis, Rule 99, Sector 1, Rules of Court. Q87. What is a guardianship proceeding? Rule 96. A. A proceeding wherein a guardian is appointed to take care of a minor or an incapacitated person's property and affairs. Legal basis, Rule 96, Sector 1, Rules of Court. Q88. What is a petition for declaration of absence or death? Rule 108. A. This is a special proceeding to declare a person as absent or presumed dead when their whereabouts are unknown, and no communication has been received for a period of time specified by law. Legal basis, Rule 108, Sector 1, Rules of Court. Q89. What is the procedure for changing names? Rule 103. A. The court grants a petition for changing names upon proof of sufficient grounds such as avoidance of confusion, embarrassment, or when necessary for the protection of the petitioner's rights. Legal basis, Rule 103, Sector 1, Rules of Court. Q90. What is the effect of a final order in special proceedings? A. A final order in special proceedings, such as a decree of probate or judicial settlement, is binding and conclusive. Legal basis, Rule 73, Sector 7, Rules of Court. Would you like me to proceed with Part 10, Judgment and Execution, or would you prefer to revisit any of the previous sections? Here is Part 10, Judgment and Execution under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 10, Judgment and Execution, Rules 39 to 44. Q91. What is the general rule regarding judgments in civil actions? A. A judgment shall be rendered based on the facts and the law as the court finds them to be. It must be clear, definite, and unequivocal, providing the party entitled to the relief. Legal basis, Rule 36, Sector 1, Rules of Court. Q92. What is the effect of a judgment after it becomes final and executory? A. Once a judgment becomes final and executory, it can no longer be appealed, and the prevailing party can initiate the process of execution to enforce the judgment. Legal basis, Rule 39, Sector 1, Rules of Court. Q93. What are the modes of execution of judgment? A. 1. Execution by delivery of a specific thing, e.g., real property or specific personal property. 2. Execution by payment of money, through the satisfaction of a monetary judgment. 3. Execution by garnishment, to seize debts or credits owed to the judgment debtor. 4. Execution by levy on real property, for the sale of property to satisfy the debt. Legal basis, Rule 39, Sector 9, Rules of Court. Q94. What is the difference between a writ of execution and a writ of possession? A. Writ of execution, issued to enforce a money judgment or deliver a specific thing. Writ of possession, issued to place the prevailing party in possession of a property after a judgment in their favor, common in land disputes. Legal basis, Rule 39, Sector 9, Rules of Court. Q95. What are the grounds for the issuance of a writ of execution? A. 1. A final and executory judgment. 2. Failure of the judgment debtor to comply voluntarily. Legal basis, Rule 39, Sector 1, Rules of Court. Q96. How long is the period for the execution of a judgment? A. A judgment may be executed within 5 years from its finality. Legal basis, Rule 39, Sector 6, Rules of Court. Q97. What is a stay of execution? A. A stay of execution postpones the enforcement of a judgment. It can be granted by the court upon a motion or for a good cause, like the filing of an appeal or the payment of a bond. Legal basis, Rule 39, Sector 19, Rules of Court. Q98. What is a motion for reconsideration in the context of judgment? A motion for reconsideration is a request to the court to reconsider or review its decision due to alleged errors of law or fact. It must be filed within 15 days from notice of the judgment. Legal basis, Rule 37, Sector 1, Rules of Court. Q99. What is a motion for new trial? A motion for new trial is filed when there is newly discovered evidence, fraud, mistake, or irregularity in the proceedings that justifies a new trial. Legal basis, Rule 37, Sector 2, Rules of Court. Q100. What is the process of garnishment in execution? A. Garnishment is the process by which the court orders a third party, e.g., a bank or employer, to turn over money or property owed to the judgment debtor to satisfy the judgment. Legal basis, Rule 39, Sector 10, Rules of Court. This concludes Part 10, Judgment and Execution. Would you like to proceed to Part 11, Provisional Remedies, or revisit any part of the review? Here is Part 11, Provisional Remedies under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 11, Provisional Remedies, Rules 57 to 61. Q101. What is the purpose of provisional remedies? A. Provisional remedies are remedies designed to preserve the status quo, prevent irreparable damage, or safeguard a party's right while the main case is pending. Legal basis, Rules 57 to 61, Rules of Court. Q102. What are the different types of provisional remedies? A. 1. Preliminary attachment. 2. Preliminary injunction. 3. Receivership. 4. Replevin. 5. Support pendant light. Legal basis, Rules 57 to 61, Rules of Court. Q103. What is preliminary attachment? A. A provisional remedy that allows a party to attach the property of the opposing party to satisfy a judgment in case the opposing party is likely to dispose of assets to avoid execution. Legal basis, Rule 57, Sector 1, Rules of Court. Q104. What are the grounds for granting a preliminary attachment? A. The grounds include 1. The party is entitled to a final judgment for a specific amount of money. 2. Fraudulent disposal of property by the defendant. 3. The defendant is about to leave the country or is a non-resident. Legal basis, Rule 57, Sector 1, Rules of Court. Q105. What is a preliminary injunction? A. A provisional remedy that orders a party to refrain from an act, restraining, or to perform a specific act, mandatory, to prevent irreparable damage to a party's rights during the pendency of the case. Legal basis, Rule 58, Sector 1, Rules of Court. Q106. How is a preliminary injunction different from a temporary restraining order, TRO? A. Preliminary injunction, issued after notice and hearing, effective until the case is decided. TRO, issued ex parte, without notice to the other party, usually lasting up to 20 days, to maintain the status quo until a hearing for a preliminary injunction is held. Legal basis, Rule 58, Secs. 5 and 7, Rules of Court. Q107. What are the requisites for the issuance of a preliminary injunction? A. 1. Clear legal right. 2. Material and substantial invasion of that right. 3. Urgency to prevent irreparable injury. Legal basis, Rule 58, Sector 3, Rules of Court. Q108. What is receivership? A. A provisional remedy where the court appoints a receiver to take custody of property, manage it, and protect the interests of the parties pending the resolution of the case. Legal basis, Rule 59, Sector 1, Rules of Court. Q109. What is replevin? A. A provisional remedy to recover possession of personal property wrongfully detained by another. Legal basis, Rule 60, Sector 1, Rules of Court. Q110. What are the requisites for filing a replevin action? A. 1. The plaintiff has the right to possession of the property. 2. The property is wrongfully detained by the defendant. 3. The description of the property and its market value is specified. 4. A bond is posted by the plaintiff. Legal basis, Rule 60, Sector 2, Rules of Court. Q111. What is support pendant light? A. A provisional remedy that requires one party to provide support, e.g., for a spouse or children, to the other during the pendency of a case. Legal basis, Rule 61, Sector 1, Rules of Court. This concludes Part 11, Provisional Remedies. Would you like to proceed to Part 12, Enforcement of Judgment, or review any specific section further? Here is Part 12, Enforcement of Judgment under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 12, Enforcement of Judgment, Rules 39 and 39A. Q112. What is the general process of enforcing a judgment? A. Enforcement of a judgment involves the use of available remedies to compel the losing party to comply with the judgment, such as execution, garnishment, or attachment. Legal basis, Rule 39, Sector 1, Rules of Court. Q113. What is a writ of execution? A. A writ of execution is a court order directing the sheriff to enforce a judgment by seizing and selling the property of the judgment debtor or by delivering a specific property. Legal basis, Rule 39, Sector 9, Rules of Court. Q114. How is a writ of execution enforced? A. The sheriff or court officer will execute the writ by either levying on real property or seizing personal property, selling the property, and applying the proceeds to satisfy the judgment. Legal basis, Rule 39, Sector 10, Rules of Court. Q115. What is the effect of a levy on real property in enforcement of judgment? A. A levy on real property involves the sheriff seizing the property, filing the levy in the Registry of Deeds, and selling the property at public auction to satisfy the judgment. Legal basis, Rule 39, Sector 10, Rules of Court. Q116. What is garnishment in the context of enforcement of judgment? A. Garnishment involves the court ordering a third party, such as an employer or bank, to withhold money or property owed to the judgment debtor to satisfy the judgment. Legal basis, Rule 39, Sector 10, Rules of Court. Q117. How long is a judgment enforceable? A. A judgment is enforceable for a period of 5 years from its finality, after which enforcement is no longer allowed unless the period is extended by the court. Legal basis, Rule 39, Sector 6, Rules of Court. Q118. What is the procedure for enforcing a judgment by delivery of specific property? A. The court will issue a writ of execution that directs the sheriff to deliver the specific property to the prevailing party, ensuring that the order is fulfilled. Legal basis, Rule 39, Sector 9, Rules of Court. Q119. Can a judgment be enforced by arrest of the judgment debtor? A. Yes, in cases where the judgment debtor fails to comply with the judgment after notice and demand, the court may issue a writ of commitment for arrest. Legal basis, Rule 39, Sector 22, Rules of Court. Q120. What happens if the judgment debtor fails to comply with the judgment? A. If the judgment debtor refuses or fails to comply with the judgment, the court may apply remedies such as contempt proceedings, arrest, or other enforcement actions. Legal basis, Rule 39, Sector 22, Rules of Court. This concludes Part 12, Enforcement of Judgment. Would you like to proceed to Part 13, Appeal, or revisit any previous section? Here is Part 13, Appeal under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 13, Appeal, Rules 40 to 45. Q121. What is the purpose of an appeal? A. An appeal is a process through which a party seeks a higher court's review of a lower court's judgment or decision, typically to correct errors of law or fact. Legal basis, Rule 40, Sector 1, Rules of Court. Q122. What are the general requirements for filing an appeal? A. 1. Notice of appeal, filed within the prescribed period. 2. Payment of appeal fee, a required fee for the appeal to be processed. 3. Record on appeal. In some cases, the appellant must submit a record containing all the relevant documents and evidence for review. Legal basis, Rule 41, Sector 2, Rules of Court. Q123. What is the effect of filing a notice of appeal? A. The filing of a notice of appeal serves as an indication that the appellant intends to challenge the lower court's decision, and it suspends the execution of the judgment unless the appellate court orders otherwise. Legal basis, Rule 41, Sector 2, Rules of Court. Q124. How is an appeal perfected? A. An appeal is perfected by the filing of a timely notice of appeal, the payment of the appeal fee, and the submission of the record on appeal, if required. Legal basis, Rule 41, Sector 6, Rules of Court. Q125. What is the distinction between an appeal by notice of appeal and an appeal by record on appeal? A. Appeal by notice of appeal, a simple filing of a notice of appeal, commonly used in civil cases. Appeal by record on appeal, required in special proceedings or actions involving the review of decisions with extensive records, requiring a comprehensive review. Legal basis, Rule 41, Sector 3, Rules of Court. Q126. What is the deadline for filing an appeal? A. An appeal must be filed within 15 days from the notice of the judgment or order. Legal basis, Rule 41, Sector 2, Rules of Court. Q127. What is a supersedeas bond, and when is it required? A. A supersedeas bond is a security provided by the appellant to stay the execution of the judgment while the appeal is pending. It is typically required in cases involving money judgments. Legal basis, Rule 41, Sector 9, Rules of Court. Q128. What is an appeal to the Court of Appeals? A. An appeal to the Court of Appeals is the process of challenging decisions or judgments of regional trial courts or quasi-judicial bodies, usually involving questions of law. Legal basis, Rule 41, Sector 1, Rules of Court. Q129. Can an appeal be dismissed for failure to perfect it? A. Yes, an appeal can be dismissed if the appellant fails to comply with the requirements for perfecting the appeal within the prescribed time. Legal basis, Rule 41, Sector 2, Rules of Court. Q130. What is the effect of an appeal from a decision of the Court of Appeals? A. An appeal from the Court of Appeals is allowed only on questions of law, and it must be filed with the Supreme Court. The judgment of the Court of Appeals remains in effect unless stayed by the Supreme Court. Legal basis, Rule 45, Sector 1, Rules of Court. Q131. What are the grounds for an appeal? A. Appeals can be based on 1. Errors of law. 2. Errors of fact. 3. Abuse of discretion by the lower court. Legal basis, Rule 41, Sector 1, Rules of Court. Q132. What is the standard of review in an appeal to the Court of Appeals? A. The Court of Appeals reviews the trial court's findings of law and fact, but generally, it will not re-evaluate the credibility of witnesses or re-examine the factual findings unless there are exceptional circumstances. Legal basis, Rule 41, Sector 1, Rules of Court. This concludes Part 13, Appeal. Would you like to continue with Part 14, Special Civil Actions, or revisit any previous section? Here is Part 14, Special Civil Actions under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 14, Special Civil Actions, Rules 62 to 71. Q133. What is a special civil action? A. A special civil action is an action that requires a specific procedure or set of rules distinct from regular civil actions. It includes actions like certiorari, prohibition, quo warranto, and others that are generally filed to protect specific rights or address special circumstances. Legal basis, Rules 62 to 71, Rules of Court. Q134. What is a petition for certiorari? A. A petition for certiorari is filed to question the jurisdiction or abuse of discretion of a lower court or tribunal, typically for decisions rendered without or in excess of jurisdiction. Legal basis, Rule 65, Sector 1, Rules of Court. Q135. What are the requisites for filing a petition for certiorari? A. 1. The lower court or tribunal must have committed an error of jurisdiction. 2. The act must be done in excess or without jurisdiction. 3. the remedy of certiorari is available because no other adequate remedy exists. Legal basis, Rule 65, Sector 1, Rules of Court. Q136. What is the purpose of a petition for prohibition? A petition for prohibition seeks to prevent a lower court, public officer, or body from acting beyond its jurisdiction or performing an unlawful act. Legal basis, Rule 65, Sector 2, Rules of Court. Q137. How does a petition for quo warranto function? A petition for quo warranto is filed to challenge the legality of a person's claim to an office, franchise, or privilege, or to remove someone unlawfully holding such a position. Legal basis, Rule 66, Sector 1, Rules of Court. Q138. What is a petition for mandamus? A petition for mandamus is filed to compel a public official or agency to perform a duty required by law that has been unlawfully neglected or refused. Legal basis, Rule 65, Sector 1, Rules of Court. Q139. What is the remedy of quo warranto in relation to corporate officers? A. The remedy of quo warranto can be used to challenge the right of an individual to hold a corporate office, particularly when the individual's election or appointment is contested. Legal basis, Rule 66, Sector 1, Rules of Court. Q140. What is the procedure for filing a special civil action for certiorari? A petition for certiorari is filed directly with the higher court, accompanied by supporting documents such as the lower court's decision, the challenged act, and any other evidence to establish that the act was done with excess or lack of jurisdiction. Legal basis, Rule 65, Sector 2, Rules of Court. Q141. What is the remedy of quo warranto for removal of public officers? A. Quo warranto is used to remove a public officer from office if the officer was not duly appointed or elected, or if they are unlawfully holding the office. Legal basis, Rule 66, Sector 1, Rules of Court. Q142. Can a decision in a special civil action be appealed? A. Yes, decisions in special civil actions may be appealed to a higher court, but only under specific grounds and following the rules of the respective special action. Legal basis, Rule 41, Sector 1, Rules of Court. Q143. What is the distinction between a writ of certiorari and a petition for prohibition? A. Certiorari, used to question a decision or act that was made without or in excess of jurisdiction. Prohibition, prevents a public authority from acting beyond jurisdiction. Legal basis, Rule 65, Sector 1 and Sector 2, Rules of Court. Q144. How is a petition for certiorari different from an appeal? A. An appeal reviews a lower court's decision, whereas certiorari is a special civil action used when a lower court or tribunal has acted in excess of jurisdiction or with grave abuse of discretion, typically without regard to the merits of the decision. Legal basis, Rule 65, Sector 1, Rules of Court. Q145. What is the time frame for filing a petition for certiorari? A. A petition for certiorari must be filed within 60 days from notice of the judgment or order being questioned. Legal basis, Rule 65, Sector 4, Rules of Court. This concludes Part 14, Special Civil Actions. Would you like to proceed to Part 15, Provisional Remedies, or revisit any specific section? Here is Part 15, Provisional Remedies under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 15, Provisional Remedies, Rules 57 to 61. Q146. What are provisional remedies? A. Provisional remedies are remedies granted by the court before the final judgment to preserve the rights of the parties, prevent harm, or secure the enforcement of a judgment. These remedies include attachments, preliminary injunctions, and the appointment of a receiver. Legal basis, Rule 57 to 61, Rules of Court. Q147. What is a preliminary injunction? A. A preliminary injunction is a court order issued at the beginning of a case to prevent harm or maintain the status quo until the case is decided. Legal basis, Rule 58, Sector 1, Rules of Court. Q148. What are the types of injunctions under Philippine law? A. 1. Preliminary injunction, issued at the beginning of a case to prevent harm before trial. 2. Permanent injunction, issued as a final judgment to restrain further acts. Legal basis, Rule 58, Sector 1, Rules of Court. Q149. What are the requirements for issuing a preliminary injunction? A. 1. Existence of a right. The party must show a right that needs protection. 2. Irreparable injury. The injury cannot be compensated by damages. 3. No adequate remedy. There must be no other legal remedy to protect the right. Legal basis, Rule 58, Sector 6, Rules of Court. Q150. What is a writ of attachment? A. A writ of attachment is a provisional remedy that allows a court to seize the property of the defendant to secure satisfaction of the judgment, in case the defendant is likely to dispose of the property or abscond. Legal basis, Rule 57, Sector 1, Rules of Court. Q151. What is the procedure for securing a writ of attachment? A. A writ of attachment is granted by the court upon motion of the plaintiff, accompanied by an affidavit showing sufficient grounds, such as fraud, threats, or risk of asset disposal. Legal basis, Rule 57, Sector 2, Rules of Court. Q152. Under what circumstances can an attachment be issued? A. An attachment may be issued when 1. The defendant is about to dispose of property. 2. The defendant is fraudulently removing property. 3. The defendant is about to abscond, among other situations. Legal basis, Rule 57, Sector 1, Rules of Court. Q153. What is the effect of a writ of attachment on the property of the defendant? A. The writ of attachment authorizes the sheriff to seize the defendant's property to secure the judgment. The property is then held in custodia legis until the final judgment is rendered. Legal basis, Rule 57, Sector 7, Rules of Court. Q154. How long is a writ of attachment effective? A. A writ of attachment is effective for 20 days unless extended by the court. The writ can be executed within this period and requires action from the plaintiff for enforcement. Legal basis, Rule 57, Sector 3, Rules of Court. Q155. What is a receiver in provisional remedies? A. A receiver is a person appointed by the court to take control of property in litigation to protect it from loss, mismanagement, or destruction during the pendency of the case. Legal basis, Rule 59, Sector 1, Rules of Court. Q156. Under what conditions can a receiver be appointed? A. A receiver may be appointed when it is shown that the property is in danger of being lost, destroyed, or damaged, or that the rights of the parties may not be adequately protected unless a receiver is appointed. Legal basis, Rule 59, Sector 1, Rules of Court. Q157. What is the role of a receiver? A. The receiver is tasked with managing and preserving the property involved in the litigation, ensuring that it remains intact until the case is resolved, and may be required to report to the court on the status of the property. Legal basis, Rule 59, Sector 2, Rules of Court. Q158. What is the difference between an attachment and a receiver? A. Attachment, a writ directing the seizure of the defendant's property to secure the judgment, typically involving tangible assets. Receiver, an appointed person to manage or preserve property during litigation, often used when the property requires ongoing management. Legal basis, Rule 57 and Rule 59, Rules of Court. Q159. What is the effect of a preliminary injunction? A. A preliminary injunction restrains the party from certain actions or commands them to act in a specific way until the case is decided, preserving the status quo. Legal basis, Rule 58, Sector 8, Rules of Court. Q160. Can provisional remedies be appealed? A. Yes, the issuance of provisional remedies such as injunctions, attachments, and receiverships may be appealed to a higher court, depending on the circumstances and the type of remedy issued. Legal basis, Rule 41, Sector 1, Rules of Court. This concludes Part 15, Provisional Remedies. Would you like to proceed to Part 16, Summary Judgment, or revisit any previous section? Here is Part 16, Summary Judgment under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 16, Summary Judgment, Rule 35. Q161. What is a summary judgment? A. A summary judgment is a judgment entered by the court without a full trial, based on the argument that there is no genuine issue of material fact, and one party is entitled to judgment as a matter of law. Legal basis, Rule 35, Rules of Court. Q162. When can a party move for summary judgment? A. A party may move for summary judgment after the filing of the answer, before trial, and after the issues have been joined, if there is no genuine issue of material fact and the movant is entitled to judgment as a matter of law. Legal basis, Rule 35, Sector 1, Rules of Court. Q163. What are the grounds for granting summary judgment? A. Summary judgment may be granted when 1. There is no genuine issue of material fact, and 2. The moving party is entitled to judgment as a matter of law. Legal basis, Rule 35, Sector 1, Rules of Court. Q164. What is the procedure for filing a motion for summary judgment? A. 1. The motion must be filed with the court and served on all parties, with supporting affidavits or documents showing no genuine issue of material fact. 2. The motion must be made at any time after the answer is filed, but before trial. 3. The opposing party has 10 days to respond. Legal basis, Rule 35, Sector 2, Rules of Court. Q165. What happens if the court finds that there is a genuine issue of material fact? A. If the court finds that there is a genuine issue of material fact, it will deny the motion for summary judgment, and the case will proceed to trial. Legal basis, Rule 35, Sector 3, Rules of Court. Q166. Can summary judgment be granted on part of the claim or defense? A. Yes, summary judgment can be granted on a part of the claim or defense if there is no genuine issue of material fact regarding that specific part. Legal basis, Rule 35, Sector 1, Rules of Court. Q167. What is the effect of a summary judgment? A. The judgment is final and conclusive on the matters adjudicated, and the case will be dismissed if the judgment is in favor of the moving party. Legal basis, Rule 35, Sector 2, Rules of Court. Q168. How does the court decide whether to grant summary judgment? A. The court evaluates whether there is a genuine issue of material fact and whether the moving party is entitled to judgment as a matter of law. This determination is made based on the pleadings, depositions, admissions, and affidavits presented. Legal basis, Rule 35, Sector 3, Rules of Court. Q169. Can the court grant summary judgment even if one party does not file an opposition? A. Yes, the court can grant summary judgment if no genuine issue of material fact is shown by the opposing party, even if no opposition is filed. Legal basis, Rule 35, Sector 3, Rules of Court. Q170. Can a summary judgment be appealed? A. Yes, a party can appeal a summary judgment to a higher court if the judgment is rendered erroneously or if it involves issues of law. Legal basis, Rule 41, Sector 1, Rules of Court. This concludes Part 16, Summary Judgment. Would you like to proceed to Part 17, Pretrial, or revisit any previous section? Here is Part 17, Pretrial, Rule 18, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 17, Pretrial, Rule 18. Q171. What is the purpose of pretrial? A. The purpose of pretrial is to simplify the issues, explore the possibility of settlement, mark evidence, consider the propriety of amending pleadings, limit the number of witnesses, and promote a speedy and just disposition of the case. Legal basis, Rule 18, Sector 2, Rules of Court. Q172. Is pretrial mandatory in civil cases? A. Yes. Pretrial is mandatory and failure of a party to appear may result in dismissal of the action or being declared in default. Legal basis, Rule 18, Sector 1 and 5, Rules of Court. Q173. When is the pretrial held? A. The court shall set the pretrial within 30 calendar days after the last responsive pleading has been filed. Legal basis, Rule 18, Sector 1, Rules of Court. Q174. What are the consequences of a plaintiff's failure to appear at the pretrial? A. If the plaintiff fails to appear without just cause, the case may be dismissed with prejudice unless otherwise ordered by the court. Legal basis, Rule 18, Sector 5, A, Rules of Court. Q175. What happens if the defendant fails to appear at pretrial? A. The defendant may be declared in default and lose the right to present evidence. Legal basis, Rule 18, Sector 5, B, Rules of Court. Q176. What must the parties file before pretrial? A. The parties must file a pretrial brief at least 3 days before the pretrial, containing summary of admitted facts and proposed stipulations. Issues to be tried. Documents or exhibits. Witnesses and their intended testimonies. Other matters for expedient disposition. Legal basis, Rule 18, Sector 6, Rules of Court. Q177. What is the effect of failure to file a pretrial brief? A. It has the same effect as failure to appear at the pretrial, dismissal of the case, if plaintiff, or being declared in default, if defendant. Legal basis, Rule 18, Sector 6, Rules of Court. Q178. Can the pretrial be waived? A. No. The rules make it mandatory and integral to the conduct of trial. The court is required to proceed with it regardless of the position of the parties. Legal basis, Rule 18, Sector 1, Rules of Court. Q179. What is the pretrial order and what is its effect? A. The pretrial order recites the matters taken up in pretrial and binds the parties to such matters, limiting the trial to those issues not resolved. It controls the course of the action. Legal basis, Rule 18, Sector 7, Rules of Court. Q180. Is mediation part of pretrial proceedings? A. Yes. After pretrial, cases are referred to court-annexed mediation, CAM, and if not settled, to judicial dispute resolution, JDR, in qualified cases. Legal basis, AM number 19-10-20 SC, Revised Guidelines for Mediation and JDR, Rule 18. This concludes Part 17, Pretrial. Would you like to proceed to Part 18, Trial, or revisit any earlier part? Here is Part 18, Trial, Rules 30 and 31, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 18, Trial, Rules 30 and 31. Q181. When does trial begin in civil cases? A. Trial begins after pretrial and termination of mediation proceedings. The court sets continuous trial dates, which must be concluded within 90 days from the first trial date. Legal basis, Rule 30, Sector 1, Rules of Court, Supreme Court Guidelines for Continuous Trial. Q182. What is meant by continuous trial? A. Continuous trial means there shall be no postponement except for exceptional reasons. Hearings are held successively until completed within the required period. Legal basis, Rule 30, Sector 2, Rules of Court, AM number 03-1-09 SC. Q183. Who presents evidence first during trial? A. The plaintiff presents evidence first, followed by the defendant. If the defendant raises affirmative defenses or counterclaims, he also presents evidence after the plaintiff. Legal basis, Rule 30, Sector 5, Rules of Court. Q184. What are the components of trial proper? A. Trial includes presentation of evidence by plaintiff, cross-examination by the defense, presentation of defense evidence, rebuttal, if any, offer of evidence, submission of memoranda or decision. Legal basis, Rules 30 and 132 to 133, Rules of Court. Q185. What happens if a party fails to appear at trial? A. If a party fails to appear without just cause, the court may dismiss the case, if plaintiff, allow ex parte presentation of evidence, if defendant. Legal basis, Rule 18, Sector 5, Rule 30, Sector 3, Rules of Court. Q186. What is an offer of evidence? A. An offer of evidence is a formal presentation of documentary or object evidence for admission by the court. It must be made after the presentation of testimonial evidence. Legal basis, Rule 132, Sector 34, Rules of Court. Q187. Can a trial be postponed? A. Yes, but only for meritorious reasons such as illness, unavailability of counsel, or other justifiable grounds. Courts strictly discourage postponements to avoid delays. Legal basis, Rule 30, Sector 2, Rules of Court. Q188. What is the rule on adjournment of hearings? A. The court may adjourn hearings for good cause to a specified date, but must ensure the case is terminated within the timeframe mandated by law. Legal basis, Rule 30, Sector 3, Rules of Court. Q189. What is consolidation of actions? A. Consolidation is the uniting of two or more cases involving common questions of law or fact to avoid unnecessary cost and delay. It may be ordered by the court. Legal basis, Rule 31, Sector 1, Rules of Court. Q190. What are the types of consolidation? A. 1. Actual consolidation, merged into one case. 2. Trial consolidation, tried jointly but retains separate identities. 3. A quasi-consolidation, one case tried, the others stayed until resolution. Legal basis, jurisprudence, e.g., Republic v. Sandiganbayan, GR number 90478. This concludes Part 18, Trial. Would you like to proceed to Part 19, Judgment, or review a previous section? Here is Part 19, Judgment, Rule 36, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 19, Judgment, Rule 36. Q191. What is a judgment under the Rules of Court? A. A judgment is the final adjudication by the court that resolves the issues in the case and determines the rights and obligations of the parties. Legal basis, Rule 36, Sector 1, Rules of Court. Q192. When must a judgment be rendered? A. A judgment must be rendered within 90 calendar days from the submission of the case for decision. Legal basis, Rule 36, Sector 1, Rules of Court, 1987 Constitution, Art. 8, Sector 15, 1. Q193. What are the requirements of a valid judgment? A. A valid judgment must 1. Be in writing. 2. Be personally and directly prepared by the judge. 3. Clearly state the facts and the law on which it is based. Legal basis, Rule 36, Sector 1, Rules of Court. Q194. What is a judgment on the pleadings? A. It is a judgment rendered when the answer fails to tender an issue or admits the material allegations of the complaint. Legal basis, Rule 34, Sector 1, Rules of Court. Q195. What is a judgment by default? A. It is a judgment rendered against a defendant who fails to file an answer or appear during trial, despite proper service of summons. Legal basis, Rule 9, Sector 3, Rule 18, Sector 5, Rules of Court. Q196. Can a court render a partial judgment? A. Yes. When the case involves multiple claims or parties, and some can be resolved separately, the court may render partial judgment on such claims. Legal basis, Rule 36, Sector 1, Rules of Court. Q197. What is the doctrine of immutability of judgment? A. Once a judgment becomes final and executory, it can no longer be modified in any respect, except to correct clerical errors, clarify ambiguity, or for nunc pro tunc entries. Legal basis, jurisprudence, e.g., Republic v. Sandiganbayan, GR number 112708. Q198. What are the remedies against a judgment? A. The remedies include 1. Motion for reconsideration. 2. Motion for new trial. 3. Appeal. 4. Petition for relief from judgment. 5. Annulment of judgment. Legal basis, Rules 37, 38, 41, and 47, Rules of Court. Q199. What is a dispositive portion of a judgment? A. It is the final paragraph or section of the judgment that states the precise action ordered by the court, such as granting relief or dismissing the case. Legal basis, Rule 36, Sector 1, Rules of Court. Q200. Is oral rendition of judgment allowed? A. No. Judgment must be in writing and signed by the judge. Oral pronouncements have no legal effect unless reduced to writing and duly signed. Legal basis, Rule 36, Sector 1, Rules of Court. This concludes Part 19, Judgment. Would you like to proceed to Part 20, Post-Judgment Remedies, Motion for New Trial and Reconsideration? Here is Part 20, Post-Judgment Remedies, Rule 37, Motion for New Trial or Reconsideration, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 20, Post-Judgment Remedies, Rule 37. Q201. What are the post-judgment remedies under Rule 37? A. Rule 37 provides two remedies. 1. Motion for new trial. 2. Motion for reconsideration. Both must be filed within 15 calendar days from notice of judgment or final order. Legal basis, Rule 37, Secs. 1 and 2, Rules of Court. Q202. What are the grounds for a motion for new trial? A. 1. Fraud, accident, mistake, or excusable negligence, fame, which prevented a party from fairly presenting their case. 2. Newly discovered evidence that could not have been discovered earlier with reasonable diligence and would probably alter the result. Legal basis, Rule 37, Sector 1, A, Rules of Court. Q203. What are the grounds for a motion for reconsideration? A. The only ground is that the decision or final order is contrary to law or evidence. Legal basis, Rule 37, Sector 1, B, Rules of Court. Q204. Can a party file both a motion for new trial and reconsideration? A. No. The rule prohibits a second motion on the same judgment. A party must choose only one. Legal basis, Rule 37, Sector 5, Rule 52, Sector 2, Rules of Court. Q205. What is the effect of a timely motion for new trial or reconsideration? A. It suspends the running of the period to appeal. If denied, the party has the remaining balance of the 15-day period to perfect an appeal. Legal basis, Rule 37, Sector 1, Rule 41, Sector 3, Rules of Court. Q206. What must accompany a motion for new trial based on newly discovered evidence? A. The motion must be supported by affidavits of merit and newly discovered evidence, along with proof that it was not discoverable earlier despite due diligence. Legal basis, Rule 37, Sector 2, Rules of Court. Q207. Is a hearing required for a motion for new trial or reconsideration? A. No, unless the court finds it necessary. Generally, the court may resolve it based on the pleadings. Legal basis, Rule 15, Sector 4 in relation to Rule 37. Q208. What happens if a motion for new trial is granted? A. The judgment is set aside, and the case is reopened for new trial on all or specified issues, with proper admission of new evidence. Legal basis, Rule 37, Sector 6, Rules of Court. Q209. What is the fresh period rule? A. Under NAPES v. ACA, GR number 141524, a party has a fresh 15-day period to appeal, counted from notice of denial of the motion for new trial or reconsideration. Legal basis, NAPES v. Court of Appeals, GR number 141524, 2005. Q210. Is a second motion for reconsideration allowed? A. No, a second motion for reconsideration is prohibited except for compelling reasons and with express leave of court. Legal basis, Rule 52, Sector 2, Rules of Court, SC Circulars. This concludes Part 20, Post-Judgment Remedies. Would you like to proceed to Part 21, Relief from Judgments, Rule 38, or revisit any topic? Here is Part 21, Relief from Judgments, Orders, or Other Proceedings, Rule 38, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 21, Relief from Judgments, Orders, or Other Proceedings, Rule 38. Q211. What is a petition for relief from judgment? A. It is an equitable remedy allowing a party to seek relief from a judgment, final order, or other proceeding when prevented from taking legal action due to fraud, accident, mistake, or excusable negligence, fame. Legal basis, Rule 38, Sector 1, Rules of Court. Q212. When may a petition for relief be filed? A. within 60 days from knowledge of the judgment, order, or proceeding, but not more than 6 months from entry of judgment or final order. Legal basis, Rule 38, Sector 3, Rules of Court. Q213. What are the requisites for a petition for relief? A. 1. Judgment or order was entered against the petitioner. 2. The petitioner was prevented from appearing or filing an appeal due to fame. 3. The petition is filed within the reglementary period. 4. The petition must be verified and accompanied by affidavits of merit and certified true copies of relevant pleadings. Legal basis, Rule 38, Secs. 1 to 3, Rules of Court. Q214. Is a petition for relief available against interlocutory orders? A. No. It applies only to judgments, final orders, or proceedings that dispose of the case or a matter completely. Legal basis, Rule 38, Sector 1, Rules of Court. Q215. Can a petition for relief be availed of in criminal cases? A. No, it is not applicable in criminal proceedings. Remedies in criminal cases are governed by different rules, such as motions for reconsideration or appeal. Legal basis, Jurisprudence, People v. Court of Appeals, GR number 125660. Q216. What is the effect of filing a petition for relief? A. Filing the petition does not automatically stay execution. The petitioner must file a motion to stay execution and post a bond, if required. Legal basis, Rule 38, Sector 5, Rules of Court. Q217. Can a party avail of Rule 38 if he already filed a motion for reconsideration or new trial? A. Yes, provided the petition is based on grounds not previously available and filed within the allowable period. However, it is generally not a substitute for lost remedies like appeal. Legal basis, Jurisprudence, Republic v. SCA, GR number 120295. Q218. What is the consequence of filing a petition for relief beyond the reglementary period? A. The court has no jurisdiction to grant the petition if it is filed beyond 60 days from knowledge or 6 months from entry of judgment. Legal basis, Rule 38, Sector 3, Jurisprudence, Domingo v. Court of Appeals, GR number 122660. Q219. Is Rule 38 a matter of right? A. No, it is discretionary and equitable in nature. Courts grant it only in exceptional cases where justice requires reopening of the case. Legal basis, Jurisprudence, Cabrera v. Francisco, GR number 154303. Q220. What is an affidavit of merit? A. It is a sworn statement detailing the facts constituting fame and setting forth a valid and meritorious defense or cause of action to justify the reopening of the case. Legal basis, Rule 38, Sector 3, Rules of Court. This concludes Part 21, Relief from Judgments, Rule 38. Would you like to proceed to Part 22, Appeal, Rules 40 to 45, 50 to 52? Here is Part 22, Appeals, Rules 40 to 45, 50 to 52, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 22, Appeals, Rules 40 to 45, 50 to 52. Q221. What are the modes of appeal under Philippine Rules of Court? A. 1. Ordinary appeal, Rule 41, from RTC to CA on questions of fact or law. 2. Petition for review, Rule 42, from RTC to CA in cases decided in the exercise of appellate jurisdiction. 3. Appeal by certiorari, Rule 45, from CA, CTA and bank, or other quasi-judicial bodies to SC on pure questions of law. 4. Appeal from MTC to RTC, Rule 40, on questions of fact and law. 5. Appeal from quasi-judicial bodies to CA, Rule 43. Legal basis, Rules 40 to 45, Rules of Court. Q222. What is the reglementary period to appeal an ordinary judgment? A. The appeal must be filed within 15 calendar days from notice of judgment or denial of a motion for reconsideration or new trial. Legal basis, Rule 41, Sector 3, Rules of Court, NAPES Doctrine. Q223. What is the fresh period rule? A. A litigant has a fresh 15-day period to appeal counted from receipt of the order denying the motion for new trial or reconsideration. Legal basis, NAPES v. ICA, GR number 141524, 2005. Q224. What is an appeal from MTC to RTC governed by? A. By Rule 40. It must be filed within 15 days from notice of judgment with payment of docket fees. Legal basis, Rule 40, Sector 2, Rules of Court. Q225. What is a record on appeal and when is it required? A. It is a pleading showing the case history and is required only in special proceedings or multiple appeals. Legal basis, Rule 41, Sector 6, Rules of Court. Q226. What is the difference between Rule 41 and Rule 42? A. Rule 41, Ordinary Appeal, is used when RTC decides a case in its original jurisdiction. Rule 42, Petition for Review, is used when RTC decides in its appellate jurisdiction. Legal basis, Rules 41 and 42, Rules of Court. Q227. What is an appeal by certiorari under Rule 45? A. A petition filed directly to the Supreme Court raising only questions of law. It must be filed within 15 days from notice of judgment. Legal basis, Rule 45, Sector 1, Rules of Court. Q228. When is a question of law deemed involved? A. When the issue does not involve the truth or falsehood of facts but the proper application or interpretation of law. Legal basis, Jurisprudence, Republic v. Sandiganbayan, GR number 112708. Q229. When is an appeal dismissed under Rule 50? A. An appeal may be dismissed for 1. Failure to file the brief. 2. Failure to pay docket fees. 3. Late appeal. 4. Abandonment. Legal basis, Rule 50, Sector 1, Rules of Court. Q230. Can new issues be raised on appeal? A. No. Issues not raised in the lower court cannot be raised for the first time on appeal, except for pure questions of law or errors affecting jurisdiction. Legal basis, Rule 44, Sector 15, Jurisprudence, Heirs of San Andres v. Rodriguez, GR number 155083. This concludes Part 22, Appeals. Would you like to proceed to Part 23, Annulment of Judgments, Rule 47? Here is Part 23, Annulment of Judgments or Final Orders and Resolutions, Rule 47, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 23, Annulment of Judgments, Rule 47. Q231. What is an annulment of judgment under Rule 47? A. It is a special remedy filed before the Court of Appeals to nullify a judgment or final order of the RTC when ordinary remedies like appeal or petition for relief are no longer available through no fault of the petitioner. Legal basis, Rule 47, Sector 1, Rules of Court. Q232. What are the grounds for annulment of judgment under Rule 47? A. 1. Extrinsic fraud, not discoverable during the trial despite due diligence and not availed of in a motion for new trial. 2. Lack of jurisdiction over the person of the defendant or the subject matter. Legal basis, Rule 47, Sector 2, Rules of Court. Q233. What is extrinsic fraud? A. Fraud that prevents a party from fully presenting their case, such as being deliberately misled or prevented from attending the trial. Legal basis, Jurisprudence, Domingo v. Isye, GR number 119125. Q234. What is the prescriptive period for filing an annulment of judgment? A. 4 years from discovery of the fraud for extrinsic fraud. No time limit for lack of jurisdiction, as a void judgment may be attacked at any time. Legal basis, Rule 47, Sector 3, Rules of Court. Q235. What should accompany a petition for annulment of judgment? A. The petition must be verified, supported by affidavits or documents showing petitioner's good and substantial cause for failure to avail of other remedies. Legal basis, Rule 47, Sector 4, Rules of Court. Q236. What is the effect if annulment is granted on the ground of lack of jurisdiction? A. The judgment is void, and the case may be retried or refiled depending on the circumstances. Legal basis, Rule 47, Sector 7, Rules of Court. Q237. What is the effect if annulment is granted on the ground of extrinsic fraud? A. The judgment is set aside, and the case is retried in the RTC as if a motion for new trial had been granted. Legal basis, Rule 47, Sector 7, Rules of Court. Q238. Can Rule 47 be used against judgments of MTC or quasi-judicial bodies? A. No. It applies only to RTC judgments. For quasi-judicial bodies, Rule 43 applies. Legal basis, Rule 47, Sector 1, Rule 43, Rules of Court. Q239. Can an annulment under Rule 47 be combined with other remedies? A. No. It is only available when no other remedy is available without fault of petitioner. Legal basis, Rule 47, Sector 1, Rules of Court. Q240. What is the effect of an annulment on prescription? A. If the RTC judgment is annulled, the prescriptive period for refiling the original action is suspended from the filing of the original case until finality of the annulment judgment. Legal basis, Rule 47, Sector 8, Rules of Court. This concludes Part 23, Annulment of Judgments, Rule 47. Would you like to proceed to Part 24, Provisional Remedies, Rules 57 to 61? Here is Part 24, Provisional Remedies, Rules 57 to 61, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 24, Provisional Remedies, Rules 57 to 61. Q241. What are provisional remedies? A. These are temporary measures available during the pendency of a case to preserve rights or protect interests until final judgment. Legal basis, Rules 57 to 61, Rules of Court. Q242. What are the kinds of provisional remedies? A. 1. Preliminary attachment, Rule 57. 2. Preliminary injunction, Rule 58. 3. Receivership, Rule 59. 4. Replevin, Rule 60. 5. Support pendant light, Rule 61. Rule 57. Preliminary attachment. Q243. What is preliminary attachment? A. It is a remedy to seize the property of the adverse party to secure satisfaction of a favorable judgment. Legal basis, Rule 57, Sector 1, Rules of Court. Q244. What are the grounds for preliminary attachment? A. Examples. Fraudulent disposal of property. Non-residency. Intent to defraud creditors. Action for recovery of a specified amount. Legal basis, Rule 57, Sector 1, Rules of Court. Q245. Is a bond required for preliminary attachment? A. Yes. The applicant must post an attachment bond to cover potential damages to the adverse party if the attachment is later found improper. Legal basis, Rule 57, Sector 4, Rules of Court. Rule 58, Preliminary Injunction. Q246. What is a preliminary injunction? A. It is an order requiring a party to do or refrain from doing a particular act to preserve the status quo pending litigation. Legal basis, Rule 58, Sector 1, Rules of Court. Q247. What is the difference between a temporary restraining order, TRO, and a preliminary injunction? A. TRO is temporary, 20 days in RTC, 60 days in CA, effective until further orders in SC. Preliminary injunction is issued after hearing and may last until final judgment. Legal basis, Rule 58, Secs. 4 to 5, Rules of Court. Q248. What are the requisites for issuing a preliminary injunction? A. 1. Clear legal right in favor of applicant. 2. Violation or threat thereof. 3. Substantial injury if not restrained. 4. No other adequate remedy at law. Legal basis, Rule 58, Sector 3, Rules of Court. Rule 59, Receivership. Q249. What is receivership? A. A remedy where the court appoints a receiver to preserve or administer property in litigation that is in danger of loss, dissipation, or mismanagement. Legal basis. Rule 59, Sector 1, Rules of Court. Rule 60, Replevin. Q250. What is replevin? A. It is an action for the recovery of personal property wrongfully detained by another, with possible delivery pending resolution. Legal basis. Rule 60, Sector 1, Rules of Court. Q251. What is required before a writ of replevin is issued? A. Affidavit showing ownership or right to possess. Bond equal to twice the value of the property. Legal basis. Rule 60, Sector 2, Rules of Court. Rule 61. Support pendant light. Q252. What is support pendant light? A. It is temporary support granted during the pendency of an action for support, legal separation, annulment, or custody. Legal basis. Rule 61, Sector 1, Rules of Court. Q253. Is a hearing required before issuing support pendant light? A. No. The court may grant it based on verified application and supporting affidavits/documents. Legal basis. Rule 61, Sector 2, Rules of Court. This concludes Part 24, Provisional Remedies. Would you like to continue to Part 25, Special Civil Actions, Rules 62 to 71? Here is Part 25, Special Civil Actions, Rules 62 to 71, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 25, Special Civil Actions, Rules 62 to 71. Special civil actions are distinct from ordinary civil actions because they have special rules that supplement or modify the ordinary rules of procedure. Rule 62, Interpleader. Q254. What is an interpleader? A. It is a remedy where a party, plaintiff, who claims no interest in a subject matter sues two or more parties, defendants, who assert conflicting claims over it. Legal basis. Rule 62, Sector 1, Rules of Court. Rule 63, Declaratory Relief and Similar Remedies. Q255. What is declaratory relief? A. It is filed by a person interested under a deed, contract, or statute before breach, to seek judicial clarification of rights. Legal basis. Rule 63, Sector 1, Rules of Court. Rule 64, Review of Judgments of COMELEC and COA. Q256. What is the proper remedy to review COMELEC or COA decisions? A. A verified petition for certiorari under Rule 64, filed with the Supreme Court within 30 days from notice. Legal basis. Rule 64, Sector 3, Rules of Court. Rule 65, Certiorari, Prohibition, and Mandamus. Q257. When is certiorari proper under Rule 65? A. When a tribunal acts without or in excess of jurisdiction, or with grave abuse of discretion, and there is no appeal or plain, speedy, and adequate remedy in the ordinary course of law. Legal basis. Rule 65, Sector 1, Rules of Court. Q258. When is prohibition proper? A. To prevent a tribunal or person from performing an act without or in excess of jurisdiction. Legal basis. Rule 65, Sector 2, Rules of Court. Q259. When is mandamus proper? A. To compel a tribunal or person to perform a ministerial duty required by law. Legal basis. Rule 65, Sector 3, Rules of Court. Q260. What is the reglementary period to file a Rule 65 petition? A. 60 days from notice of judgment or order. Legal basis. Rule 65, Sector 4, Rules of Court, as amended. Rule 66, Quo warranto. Q261. What is quo warranto? A. An action to challenge the right of a person to occupy a public office or position. Legal basis. Rule 66, Sector 1, Rules of Court. Rule 67, Expropriation. Q262. What is expropriation? A. A proceeding where the government seeks to acquire private property for public use with just compensation. Legal basis. Rule 67, Sector 1, Rules of Court. Rule 68, foreclosure of real estate mortgage. Q263, what happens in a judicial foreclosure? A. The court orders the mortgaged property sold to satisfy the debt. Legal basis, Rule 68, Rules of Court. Rule 69, partition. Q264, what is partition? A. A proceeding to divide property held in common among co-owners. Legal basis, Rule 69, Rules of Court. Rule 70, forcible entry and unlawful detainer. Q265, what is the difference between forcible entry and unlawful detainer? A. Forcible entry, deprivation of possession by force or stealth. Unlawful detainer, withholding possession after lawful possession has expired. Legal basis, Rule 70, Sector 1, Rules of Court. Rule 71, Contempt. Q266, what are the kinds of contempt? A. 1. Direct contempt, committed in the presence of the court. 2. Indirect contempt, committed outside the court. Legal basis, Rule 71, Sex. 1 and 3, Rules of Court. This concludes Part 25, Special Civil Actions. Would you like to proceed to Part 26, Special Proceedings, Rules 72 to 109? Here is Part 26, Special Proceedings, Rules 72 to 109, under Civil Procedure for the 2025 Philippine Bar Exam. Civil Procedure, Part 26, Special Proceedings, Rules 72 to 109. Special proceedings are remedies by which a party seeks to establish a status, right, or particular fact, rather than to obtain relief against an adverse party. Rule 72, General Provisions. Q267, what governs special proceedings? A. The Rules of Court, particularly Rules 72 to 109, supplemented by rules for ordinary civil actions when applicable. Legal basis, Rule 72, Sector 2, Rules of Court. Rule 73 to 91, Settlement of Estate of Deceased Persons. Q268, where is the proper venue for the probate of a will? A. If resident, RTC of the province where the deceased resided at the time of death. If non-resident, RTC of any province where the estate may be found. Legal basis, Rule 73, Sector 1, Rules of Court. Q269, what are the modes of settling the estate of a deceased person? A. 1. Judicial settlement, with or without a will. 2. Extrajudicial settlement, if no will, no debts, and all heirs agree. Legal basis, Rule 74, Sector 1, Rules of Court. Q270, what is the purpose of probate of a will? A. To establish the validity and due execution of a will. Legal basis, Rule 75, Rules of Court. Q271, what is the order of preference in the appointment of administrator? A. 1. Surviving spouse. 2. Next of kin. 3. Creditors. 4. Other persons the court deems fit. Legal basis, Rule 78, Sector 6, Rules of Court. Q272, who are required to post a bond in probate proceedings? A. Executors and administrators, unless expressly exempted by will. Legal basis, Rule 81, Rules of Court. Rule 92 to 97, Guardianship and Custodianship. Q273, what are the grounds for appointing a guardian? A. Minority. Insanity. Disability. Incapacity to manage affairs. Legal basis, Rule 92, Sector 2, Rule 93, Sector 2, Rules of Court. Q274, what are the duties of a guardian? A. To manage the ward's person and/or property, and render inventory and accounting. Legal basis, Rule 96, Rules of Court. Rule 98, Trustees. Q275, when is the appointment of a trustee necessary? A. When required by law, will, or contract to manage a trust property. Legal basis, Rule 98, Rules of Court. Rule 99 to 100, Adoption and Custody. Q276. What court has jurisdiction over adoption cases? A. As of RA number 11642, Domestic Administrative Adoption and Alternative Child Care Act, adoption is now handled by the National Authority for Child Care, NACC, not by courts. Legal basis, RA number 11642, Rule 99 was rendered obsolete. Q277, who may file a petition for custody of a minor? A. Any person claiming rightful custody of the child. Legal basis, Rule 99, old rules, now under AM number 03-04-04 SC. Rule 101, hospitalization of insane persons. Q278, what is the purpose of this proceeding? A. To commit an insane person to a mental institution for treatment. Legal basis, Rule 101, Rules of Court. Rule 102, Habeas Corpus. Q279, what is habeas corpus? A. A writ to inquire into the legality of a person's detention. Legal basis, Rule 102, Sector 1, Rules of Court. Rule 103 to 107, change of name, absentees, cancellation of entry in civil registry. Q280, who may file a petition for change of name? A. A person desiring to change their name for valid and justifiable reasons. Legal basis, Rule 103, Sector 1, Rules of Court. Q281, what is the process to declare a person an absentee? A. File a petition in court after 2 years of absence without communication. Legal basis, Rule 107, Rules of Court. Q282, what is the remedy for clerical errors in civil registry entries? A. File a petition under RA 9048, not Rule 108, unless the change is substantial. Legal basis, RA 9048, Rule 108, for substantial corrections. Rule 108, cancellation or correction of entries in the civil registry. Q283, what entries may be corrected under Rule 108? A. Substantial or controversial entries, like legitimacy or filiation, after full-blown adversarial proceedings. Legal basis, Rule 108, Rules of Court. Rule 109, Appeals in Special Proceedings. Q284, what is the mode of appeal in special proceedings? A. By notice of appeal or record on appeal where required. Legal basis, Rule 109, Rules of Court. This concludes Part 26, Special Proceedings, Rules 72 to 109, and the entire civil procedure subject for the 2025 bar exam. Would you like a summary flashcard set next for quick review? Here is a flashcard set for Part 26, Special Proceedings, Rules 72 to 109, of Civil Procedure under the 2025 Philippine Bar Exam. Flashcards, Part 26, Special Proceedings, Rules 72 to 109. Q1, what is the purpose of special proceedings? A. Special proceedings are designed to provide remedies for specific issues such as the settlement of estates, guardianship, adoption, or habeas corpus. Legal basis, Rules 72 to 109, Rules of Court. Q2, what does Rule 72 govern? A. General provisions on special proceedings, including the scope and application of the rules. Legal basis, Rule 72, Rules of Court. Q3, what is the rule on the probate of wills? A. The court must determine the validity and due execution of a will. It is filed in the Regional Trial Court, RTC, of the deceased's place of residence or where the estate is located. Legal basis, Rule 73, Sector 1, Rules of Court. Q4, how does the court determine venue for probate proceedings? A. If resident, RTC of the province where the deceased resided. If non-resident, RTC of any province where the estate may be found. Legal basis, Rule 73, Sector 1, Rules of Court. Q5, what is extrajudicial settlement? A. An agreement by heirs to settle the estate of a deceased without going to court, provided there is no will and no debts. Legal basis, Rule 74, Sector 1, Rules of Court. Q6, what is the purpose of letters testamentary or letters of administration? A. these are formal court orders appointing an executor or administrator to settle the estate of a deceased person. Legal basis, Rule 78, Sector 6, Rules of Court. Q7. When is guardianship appointed for a person? A. When a minor or an incapacitated person needs someone to manage their affairs, either for their person or property. Legal basis, Rule 92, Sector 2, Rules of Court. Q8. What is the process for habeas corpus? A. A petition filed to challenge unlawful detention and secure the release of an individual if their detention is deemed unlawful. Legal basis, Rule 102, Rules of Court. Q9. Who can file a petition for change of name? A. A person desiring to change their name for valid and justifiable reasons, such as avoiding confusion or embarrassment. Legal basis, Rule 103, Sector 1, Rules of Court. Q10. How does one declare someone an absentee? A. The petition is filed when a person has been missing for 2 years, and their whereabouts are unknown. Legal basis, Rule 107, Rules of Court. Q11. What does Rule 108 govern? A. The correction or cancellation of entries in the civil registry, such as errors in the name or date of birth of a person. Legal basis, Rule 108, Rules of Court. Q12. What is interpleader in special proceedings? A. A remedy allowing a person who holds property subject to conflicting claims to seek the court's determination of ownership without becoming involved in the dispute. Legal basis, Rule 62, Sector 1, Rules of Court. Q13. What does Rule 109 cover? A. Appeals in special proceedings, including the procedure for filing an appeal in cases under special proceedings. Legal basis, Rule 109, Rules of Court. Q14. What is judicial settlement of estate? A. The legal process for the court to supervise and resolve matters related to a deceased person's estate, ensuring proper distribution of assets and settling of debts. Legal basis, Rule 73, Rules of Court. Q15. What is declaratory relief? A. A special proceeding to determine rights, status, or legal relations, such as interpreting a contract or statute. Legal basis, Rule 63, Sector 1, Rules of Court. Q16. Who may be appointed a guardian under Rule 92? A. A legal guardian may be appointed for a minor or an incapacitated person, subject to the court's determination of suitability and necessity. Legal basis, Rule 92, Sector 2, Rules of Court. Q17. What is the remedy if a civil registry entry is incorrect? A. File a petition for correction of entries either for clerical or substantial errors. Legal basis, Rule 108, Rules of Court. Q18. What is the primary purpose of writ of mandamus in special proceedings? A. To compel a public official to perform an official duty required by law. Legal basis, Rule 65, Rules of Court. Q19. What proceedings are covered under Rule 99 to 107? A. These cover petitions for adoption, custody, guardianship, annulment of marriage, and related issues. Legal basis, Rules 99 to 107, Rules of Court. This concludes Part 26, Special Proceedings, Rules 72 to 109, flashcard set for the civil procedure portion of the 2025 Philippine Bar Exam. Let me know if you'd like more flashcards or assistance with other topics.